the first to know Nsem-Pii TV.
Former Chief Justice Yamami Gertrude Tokonu, ni lawyer ni Ayikoo Otoo ono former Attorney General ono and lead counsel at the Yamami Gertrude Tokonu na afei and odi nsem ni mu nokre ankasa ababetuda because said the enya enim no Yamami Gertrude Tokonu etimi akopie mu ewo the ECOWAS court time ECOWAS court share NDC amanyuko ne se wonso emra mepie mu ni asem no time no eson NDC amanyuko na anko wonso amfa reason amfa anko me no kasa idea ni lawyers led by ni Ayikoo Otoo osan former Attorney General they say one actually the court and say court no enhwe na onfa ne judgment emfa emra na nsem no sana NDC amanyuko no bebre behind the scene ama bonten na eno na lawyer Ayikoo Otoo edimu no kure nyina ababetu edwamade enkonkotie.
If you followed the program as you had told us, I did mention that Oliver Vormawor's group were the next that we were to take. That is what they call the shining stars or so. Now, on that day, they wrote a letter to say that they would not be available because Oliver himself, according to him, was having medical issues, and some of his people who would testify were equally having medical issues. So they wanted a very long adjournment. The committee therefore adjourned the case to the 15th, the hearing to the 15th of September for us to come and start. On the same day, we made it clear to them, that is the day before we had written to say that they gave us only about 5 days and that we needed a little more time, 1 week to run up. We had even raised the issue that asking both parties to file their addresses simultaneously was not the best in view of the fact that there were petitioners who are alleging wrongdoing on the part of the Chief Justice, and therefore they should have the option to tell us how they have seen this thing right from the beginning for us to respond. The committee said, no, we should still keep to what they have said. And then they told us that, look, after all, if they ask us to file it by a certain date and we have not finished, we could file it within a reasonable time. It's not by force that we should meet it by all means, but we should file it within a reasonable time. That was 25th or so. That was when we were talking. So we took the 1 week and we were about to file it on the following Monday, only to be told that the report had already been issued. If you followed me on the PM Express, I also made the point that I didn't know that Chachu and his people had even filed their submissions because we were not served. It is this morning that you started reading from it that I was taken aback and said, what is happening? You even have a copy of what they filed. So, like I said, where is the fairness? They didn't even wait for us to file whatever. They did not say that if you don't file it by a certain date, we will take it that you are no longer interested in filing. But they just went ahead, apparently having prepared whatever they wanted to prepare, and went and submitted it based upon one-sided, submission. From what you are telling me now, these were the things that Chachu told them. What about our side?
So
they didn't want to hear what we wanted to say.
Okay, so let's get to learn about the facts. You were given the 25th of August.
That is 5 days.
To file your written submissions, right?
Yes, yes.
By 25th, you had not filed.
We had not, because we were preparing to start the Shining Stars 2 at the same time.
But the petitioner, as in Daniel Ofori and his lawyers, had filed by 25th.
Nobody told us anything. Nobody. That's what I'm saying. I'm hearing it from you for the first time. because they told us we could file it within a reasonable time.
But you were giving 25th.
Agenda hearings to the 15th of September.
But you had just confirmed to me a while ago that you were giving the 25th to file.
Have I denied that?
Right. So as
we were giving.
Okay,
please,
I'm informing you.
I don't want this kind of.
No, we are doing just a bit of a fact.
Creating the impression as if I'm telling lies.
No, I'm not suggesting. I won't do that. I won't do that, sir. So I'm saying that on the 25th, the petitioner had filed their written submissions. They filed it on the 25th because that was the deadline you were giving, but you were unable to meet the deadline.
I'm saying to you that they said we should file it by the 25th. 24th, we wrote to them that we were on it, we would not be able to complete, and we needed 1 week.
Okay.
That was the day that Oliver Vomawo's group were also to start theirs. And we said, look, we are settled with 2 of them. One, to write the submission, at the same time prepare to come and meet the Oliver Vomawa people, shining stars. So could we be given 1 week to organize ourselves, file the written submission, and then start the hearing?
Okay.
And they told us that day, because it did not involve Tsikata and his group, they were not there. So what they would tell us is that they would give us an advice that we should try and file it within a reasonable period. That is all.
Okay.
And then the entire trial was then adjourned to the 15th to give Shining Stars, their lawyer, and whoever will come sufficient time to come back. What is today's date?
Right. So as I understand, you also were surprised that the committee had come up with a report on one petition when your expectation was that they will wait for the whole, all the petitions to be gone into before they present, as it were, a composite and one address or one report.
Oliver Vomawa was there on the first day when they tried to agree on the procedures they were going to adopt. And he would tell you that what they said was that they had 3 petitions. They would start with Daniel Ofori and adjourn the 2 Sanadai. When they are ready, they will call us, give us hearing notices to come, and then we go on with the other ones. So they were only going to start with Daniel Ofori. In the course of time, we received a hearing notice to appear to talk about issues being raised by Shining Stars. And I raised the objection that we are not finished with one, which you said you wanted to do. Why are you now moving on to deal with this one? He said, these are just preliminary matters because they have indicated they wanted to call so many people, to subpoena so many people, and they wanted to talk to them to let them know how these subpoenas are done. Ask him, he was there with us, for example, that day. He had not always been with us because we have only been with Daniel Ofori. So he was there the first day, then he came again for these preliminary matters to be dealt with, and that was it. I don't remember that he sat through and he can tell you what took place. I sat through and started the cross-examination from day 1 in December. On the Wednesday of May or so.
When you were agreeing on the procedure to be adopted, where the committee announced to you that they were going to use the CI 47, the High Court rules, they were going to use the High Court rules as it were, and adopt it and the High Court rules, and with necessary modifications where necessary. They had also announced to you, as in all of you, the lawyers and the parties in the room, that, quote, the trial will be petition by petition each of the three will be tried separately, end quote. Is that what you were told?
I wasn't there on the first day. It was my colleague Edu Kusi, who was present. But I read the proceedings for that day.
Okay.
And I'm saying that they told them that if you have a copy, read the entire thing and see whether you will not find them saying that they are going to adjourn the two Sanadai and call us when they are ready. Find out whether it was not agreed upon on that first day.
All right. So hold on briefly for me. I'll return to you. We'll deal with the substance.
About fairness and procedure. I thought you said that they teach law and ethics. Here is somebody who tells us that he is going to adjourn the other petition Sanadai and will call us when they are ready. He goes to the president, informs the president that indeed the people asked for adjournment and we have adjourned the case to the 15th of September. We will be going back. Why was there? Where is that indecent haste to rush and go and present the petition when you have told everybody there are two more that you intend to deal with? What is the indecent haste for? What are they trying to prevent? The ECOWAS decision or other decisions in the court? If somebody doesn't want to speculate, we will speculate. If somebody doesn't want to speculate, we will go ahead and speculate. Why? What is the rush for? What is the rush for? 1 week. As she herself put it, what would it have spoiled? If you give us 1 more week to wind up. And again, they didn't even say we are not going to grant you. So go and file immediately. What they said was that, we have all been practitioners. And I'm quoting Gabriel Puama. We have all been practitioners before. The fact that you are asked to file by a certain date, if you cannot meet it, doesn't mean that you cannot file. So just file it within a reasonable time. And then we would decide. So you are saying that there's nothing wrong when you listen to only one side. You listen to, now you are quoting things from their submission. Have you seen ours to also see what responses we gave to those things? Have you seen ours?
I would love to see that. See yours.
This is just most unfair. And everything they have done is wrong. And they are just in a hurry.
But I am not the committee. I decided myself to subject myself through 106 pages of address to read, to inform myself of the one side. But you see what addresses we cannot do is they deal with facts, even though we can be selective about the facts. So there are facts in the address that you cannot impugn. I would like to read yours.
My brother, I've been in this job
I'll lay hands on it.
40 years. I've been in this job for over 40 years. I started as a criminal lawyer and I changed because I realized that we had a right to address the court when the police prosecutors did not have the right. And I felt that what we were doing was unfair. So I left criminal practice and went to civil. You can put all sorts of things in it one way. That is what you are saying. It is when you hear the other side that you find that somebody is twisting the facts. So the mere fact that somebody has written an address doesn't mean that.
Okay, so let's not make this the subject, even though I made a small reference from it. Let's not make it the subject. And I'm careful also because when I read an address and I'm seeing records, quotations, because they are sending to the committee, they cannot, quote what does not exist in the record because it will be found out. And we don't do that as lawyers anyway. So my question...
Lawyers address the court and they put all sorts of things there because they know the prosecutors cannot address. I'm speaking from experience.
Okay. So my question now to you is that, what happens now? But first of all, you say that you agree with Sophia Kufu that, for example, the financial impropriety leg, it was not such a weighty matter that should lead to the removal of a Chief Justice, right?
I didn't say so. You see what? You also purport to be quoting me. I did not say so. let me take you through the process that I took them through, including those who sat at the committee. Vomawa was not there. We asked them, was there an audit? And they said yes. Did the audit raise queries? They said yes. Did the spending officer respond to those audit queries? They said yes. Was there a final management letter? They said yes. Did the final management letter refer to any such thing? They said no. I have a copy of the final. If you say you have the proceedings, look at it. Audit service management letter on the accounts of the judiciary for JS Judicial Service for the period 1st January 2023 to 31st December 2023, dated 30th July 2024. If you claim you have the full record, read it for yourself and tell me where in this management letter they said they have found anything wrong. The auditors who did the work.
Okay, so your point is that if the audit did not flag the issue, there should not be an issue. That's your point.
It means they agreed with the explanation given to them, including the travel policy and all. They agreed with it and they never came back to it.
Okay.
It was never raised again.
Okay.
I said, I have a copy here.
Yeah, I get that. I get that. Nobody is disputing anything you have said.
Yeah, look through yours and see whether you can find anything on that.
My question to you...
Is that the way to treat an individual?
Yeah. So it's not in controversy, so let's not get to that. My question to you is, your point is that if the auditors did not flag misuse, unlawful, expense, or unconstitutional expense, nobody should raise it again?
I am saying that when the auditors come, they look at the record. When they have issues, they raise the issues. Then they give it to the management, whoever it is who is responsible, especially the spending officer. And they ask you for your explanation. Perhaps the thing is there. They didn't see it. So then you explain to them. And once you explain to them, that ends the matter. So the fact that it was even raised in a query does not mean that is the end of the matter, because you are now given the opportunity to respond. Something you have experienced, don't you? So having responded, and they left it in the final management letter, pointing out the areas they find the judicial service didn't do well, and this one did not come out. How do you turn around? And this committee, this report was before you. I specifically asked Domelevo, who was sitting there, whether this is not a procedure. He agreed. I think he even said there's a difference between audit observation and audit query. But these days they talk about audit or observation or something.
All right.
This is what happened, and the report is there. So where is this thing coming from?
Right. So let's put the committee in perspective. From the letter to the Chief Justice, which said, in the opinion of the committee, quote, in the opinion of the committee, the travel expenses which the Chief Justice heaped on the judicial service when she traveled on holidays in September 2023, first to Tanzania with her husband and second to the United States of America with her daughter, together with the payment of per diem to the spouse and daughter of the Chief Justice, constitute unlawful expenditure of public funds. It cannot be justified in law or policy. Those acts constitute avoidable and reckless dissipation of public funds and, in the view of the committee, to have been occasioned by the overall head of the judiciary and the judicial service, whose duty it is to guard public resources allocated by the government, is caught within the spectrum of stated misbehavior. So they are saying that there's no policy allowing this. The Constitution also does not allow it. So it's both unlawful, it is also unconstitutional. You are saying once the auditor didn't make any such claims, a committee like this cannot be heard to say what they said?
Please don't trivialize it. One of the members of the Judicial Council happened to be Gabriel Scott Puama. He had always been there with them, taking all the decisions, including travel policy. I explained the last time I was here that because of the judicial independence, they also granted them financial independence and asked them to work according to what they think is best to secure their independence. And therefore, they told them that it is only the Judicial Council that can determine anything which is pertaining to them and not necessarily the executive. Not necessarily the executive. So the travel policy was something that came out from the Judicial Council where Puama has been serving. And he knows that there was this travel policy which allows the Chief Justice to travel with a person of her own choice, and that whatever, whatever per diem is given to her, the person is traveling with will be given half. These are not stories. They are all there. The Chief Justice's appointment letter stated clearly that she will be entitled to 2 vacations in a year. And she can choose wherever she wants to go. Her duty is to tell them that this is vacation period, I intend to travel. Then the spending officers will work, buy the ticket, do all the protocols, and then give her whatever her entitlements are. And then she uses that to travel. I am challenging them. Let anybody bring a document where the Judicial Service or Secretary said, these are your entitlements. And then the Chief Justice said, no, I will not accept it. Give me this rather. Nothing of the sort happened. And I'm saying I've gone through it twice as a Minister of Justice and Attorney General and as a High Commissioner. When I'm to travel, I don't get involved. All I tell them is that I need to travel. They work it and bring it to me. Which is why you have a spending officer who is held liable. How did they change it? With Domelevo sitting there, now saying that she being the overall head. Where has it happened before?